Welcome back to another episode of Terms and Conditions, the podcast by Con Maciel Carey. I am Letitia Silas. I'm a traditional labor and employment attorney and partner in the Labor and Employment Practice Group at Con Maciel Carey, a national labor and employment law firm. We represent employers in all workplace matters nationwide across a variety of industries. Here on Terms and Conditions, we demystify workplace laws by discussing the issues in a grounded and accessible way to keep you informed as an employer of choice. Be sure to follow us on LinkedIn and on all platforms where you get your podcasts, including Apple, Amazon, iHeart, and Spotify. Today, we are following up on our recent exciting webinar, Forecasting Changes to Workplace Laws in 2025. For this topic, I am joined by my colleague, Scott Hecker. Scott is Senior Counsel in the Labor and Employment Practice Group at CMC. Welcome, Scott. Can you tell us a little bit more about yourself?
Yeah, absolutely. I appreciate it, Letitia. Glad to be here with you. I am a workplace safety and labor and employment attorney. Joined the firm relatively recently, so new to the podcast, new to the firm. But came here after a time with a larger international firm, as well as about 12 years at the Department of Labor, where I did workplace safety and wage hour matters, prevailing wage issues, both at the trial level, appellate level, reg writing, and all those things. I was actually the acting director of strategic planning and performance for the wage and hour division during the first Trump administration. So have a little bit of an idea to how the sausage is made, and looking forward to chatting through some of these issues with you today.
Absolutely. So, Scott, as you know, and you were part of this, we just had our webinar last month where we predicted the current administration's movement in the workplace law space immediately following the inauguration. I mean, we had a full list of things that we thought the current administration would do to accomplish its goal of cutting federal regulations and federal government expenditures and restructuring federal agencies. We talked about two primary areas of doing so, and that was reducing administrative power and shifting toward deregulation. Can you talk about both of those just a little bit?
Yeah, absolutely. I think we've seen, through the tail end of the Biden administration, some Supreme Court activity, cases like Loper Bright, Jarchese, Corner Post, that suggest an effort by the judiciary to rein in the authority of the administrative state through limiting that authority, through determining how the executive branch can actually execute the laws and how much responsibility it can take on, as opposed to the other co-equal branches of government. And the shift towards deregulation, I think, goes hand in hand with that. You can expect, we saw it in the first Trump administration, you can expect it in this administration, that there'll be kind of a walk back from regulation. I would expect there will be withdrawal of some of the regulations that were issued during Biden's administration, or, a decision not to defend them if they're being challenged in court, and, less proactive rulemaking. The first Trump administration had if you issue one rule, you have to withdraw two. I think we've heard numbers that are, if you issue one, you have to withdraw 10. I've heard that rumor. So it's unclear how much withdrawal there will be, but I think we can expect deregulation. And the other thing we've seen that I think you alluded to is just when it comes to the restructuring of the federal government and executive agencies, Elon Musk's DOGE, the Department of Government Efficiency, has already upended a lot of the norms we've seen in the past, leading to some folks taking a voluntary buyout, others, looking to leave the administration for other reasons, and potential for RIFs, reductions in force. So that's another way to limit agency power, is just to not have that many people working there.
Right. And we're not going to get into the politics of all of that. But, a lot of this is going to be challenged in the courts, and there are going to be legal battles probably for a long time. So with that said, Scott, I would like to dive into some of how all of this has manifested in three areas: wage and hour law, Title VII enforcement, and private sector labor law. Can we start there and start with the Department of Labor?
Sure. And yeah, I mean, specifically when it comes to wage and hour, wage and hour has pretty significant enforcement authority. The statute that a lot of folks probably encounter is the Fair Labor Standards Act, which has minimum wage and overtime requirements. And so a lot of our clients, employers, the work I've done has to do with that and how those requirements are executed out in the field by HR folks, by companies just trying to comply with those regs. And so wage and hour, that enforcement activity we expect to continue. You know, the level can vary depending on the administration, but certainly we expect investigations to continue and to be ongoing. And so employers need to keep those rules in mind. There hasn't been a lot of activity on the leadership front at wage and hour yet. We're still early in the administration, of course. Interestingly, there have been some nominees named at the top where you have former Congresswoman Chavez DeRemer out of Oregon, who has been named as the secretary nominee. You have Keith Sonderling, who worked in the Wage and Hour Division, worked at DOL, and was an EEOC commissioner. He is nominated as the deputy secretary. We haven't seen a Wage and Hour Division administrator nominee yet. Interestingly, there's been some activity. I also do some OSHA work, so there's been activity on that front. A deputy assistant has been named, Amanda Wood-Lehau, who was an OSHA commissioner, and David Keeling, who is named as the potential OSHA assistant secretary. He was global health and safety vice president at UPS. He spent time in safety at Amazon. So these are folks that have some experience, and overall, I would say the nominees at DOL seem pretty balanced and mainstream. Others can disagree about nominees in other agencies, but this one seems fairly mainstream for the folks who've been put up. On that front, I would say I'm sure our OSHA and MSHA practice groups are going to be discussing these issues, and they both have webinar series that you can learn more about on our website, our firm website. So I would suggest, they'll be chatting about the substance in those areas, and so it makes sense to kind of follow up there if you want more info on the workplace safety front. But getting back to sort of the wage and hour piece, there are a lot of interesting things that happened during the last administration when it comes to wage and hour. We saw an effort to increase the OT threshold, though that was vacated. But in other spaces.
You say OT, you mean the overtime?
Sorry, overtime.
Threshold?
Yes, correct.
Okay.
The overtime.
And so,
threshold.
what was it before, and what were they trying to change it to?
Yeah, so it's back to what it was before, and off the top of my head, I'm going to say 35,888, but I'm not 100% sure on that number. So please.
What does 3588 mean? $35.88, or make it plain for us.
Yep, $35,888. But I don't think that's. I wouldn't quote me on that number, but you're looking at mid 30,000. And let's pause for a second and cut that. Let me look that up real quick, and I'll make it clear. Yeah, and for example, Letitia, we saw a lot of activity in the wage and hour space during the Biden administration. The overtime threshold rule, for example, was a big deal. Most folks who are non-exempt employees need to get paid time and a half is the typical system for overtime hours, over 40 in a work week. We saw a change in that. The Biden administration wanted to increase the threshold to make more folks overtime eligible, and so the number had been at sorry. God, what am I doing here? Apologies. Can I just jump back in?
Just go in. Just keep going. We'll edit that from.
So the previous threshold for overtime, the overtime exemption for exempt employees was $684 a week, or $35,568 per year, $35,568 per year. The Biden administration's rule had sort of a biphasic approach. There was an initial threshold increase in July of 2024, and that took it to 844 per week, or 43,888 per year. And then there was going to be a second threshold at the beginning of 2025 to 1128 per week, or 58,656 per year. Now, the July 1st one went into effect, but was vacated. And the January 1st, 2025 never happened. And so we're back actually to the Trump era 35,568 number. And so that is interesting just to see whether there will be a change there, whether President Trump will revisit that, because he did engage in rulemaking on the overtime front in his first administration. So will he look for lower thresholds and try still to sort of increase that and make more people overtime eligible? He's floated the idea of making overtime non-taxable. So, he's looking at things in that space. But there are certainly other issues that we can see and I can speak to in the wage and hour space when it comes to other areas for kind of minimum wage or pay changes. For example, there was a federal contractor minimum wage executive order 14026 during President Biden, which increased the pay for folks working on federal contracts. Right now, that number is at $17.75 per hour. And so there's a question. There have been some cases, some challenges of that rule, including the Ninth Circuit vacated it, the 10th Circuit did not, and the 5th Circuit actually recently upheld it earlier in February. So the Supreme Court declined to take up the 10th Circuit decision, but we do have a circuit split, so unclear kind of where that will go and whether President Trump will continue to defend those regs and push for a higher minimum rate for government contractors. Akin to that are prevailing wage laws that we see under Davis-Bacon Act or the Service Contract Act, for example. Davis-Bacon was changed during the Biden administration, so we'll see. Maybe there'll be a change in the way those prevailing wage rates. And prevailing wage rates are basically, what wages are prevailing in a certain area that contractors need to be paid based on wage determinations that the department puts out.
Well, you said a lot there, so
I
want to unpack. I want to unpack some of that. The first one is you talked about the movement that we are seeing in the minimum wage space. And I want to clarify, we're talking about the federal minimum wage. States and municipalities, localities may have their own minimum wages, which are higher generally than the federal minimum wage. So you still have to comply with those regardless of what's happening at the federal level. Just clarify for everybody. Yep. The other thing, Scott, is why is this really important to employers? Why do employers really need to keep their eye on the ball in terms of where we land on minimum wage at the federal level?
Yeah, I mean, the compliance aspect is one thing. You could have enforcement exposure if you're not meeting the thresholds across these different, obligations. But your allusion to the states is also important too, because you're going to need to pay the higher. For example, if you have a wage determination with a prevailing wage rate for a shipping and receiving clerk that says, $17.75 per hour, but the state minimum wage is $18 an hour, you need to pay that $18. So it's important to stay on top of the various requirements that you may be subject to. And it's certainly a burden on multi-jurisdictional employers to kind of figure out, okay, should I think about paying a base rate to everyone that is the highest floor that I need to set? Do I want to pay different things across different jurisdictions? There's an administrative cost there, right? And a burden to stay on top of it. So it's key to just know what the current obligations are so that you can maintain compliance, so that you can, budget appropriately for each year and when changes are coming, and so that you can manage your workforce and ensure, positive morale, that people feel like they're being taken care of and the laws are being met around pay. It's obviously a big important deal for the workers to make sure they're getting paid and paid appropriately. Otherwise, you can have disgruntled folks. And again, the potential for enforcement activity is certainly there if you're not in compliance.
Not only enforcement actions, but your employees might start wanting to form a union. And
Yeah,
that's
well,
one of the main reasons why people say they
yep.
want a union, is that they feel like their pay is not fair. And if the pay is unlawful, then it's not fair. And so you want to be mindful of that. So, Scott, I want to unpack a little bit on that enforcement piece, because I know in wage and hour, the enforcement piece and the potential financial costs are higher than just make whole remedies, which is what I see in the traditional labor space. Can you talk about that, how it's more than just potentially make whole remedies?
Yeah, I mean, you can wind up with civil money penalties assessed against you. That's something that Wage and Hour has the authority to do. We saw that in the last administration a lot in the child labor violation space, actually. They changed their methodology for how to calculate those kinds of penalties in, I want to say, November of 23. There were a couple memorandum issued that sort of changed the way child labor was looked at. There was kind of a whole of government effort there. I don't know that we're going to see that push to the same extent, but the authority to issue penalties is out there. And so, also depending on the context and the statute at issue, you may have the potential for reinstatement, which has costs both, financially. And so, yeah, we have the potential for those kinds of penalties. Another option is, under certain statutory frameworks, you may have reinstatement, back pay, front pay, those kinds of things that, are additional exposures to just, as you say, to make whole kind of, what are you owed and that's it. There are other potential remedies out there for employees who were allegedly, there was alleged violations around their pay, or whistleblower retaliation, those kinds of things as well. And that's an overlap, I think, with your union work. But we saw a lot of explicit anti-retaliation provisions added or emphasized under the Biden administration. Giving a voice in particular to vulnerable workers. Again, we'll see what that policy looks like going forward, but that may not be as big a focus under the Trump administration.
Excellent. Could you explain what treble damages are and what the potential is for such a award under FLSA or under wage and hour enforcement actions?
So yeah, under the Fair Labor Standards Act, there are actually liquidated damages available, and those are double. So that'll be, whatever the back wages due may have been calculated by the department. And this could be minimum wage owed, overtime owed, whatever it is. The department can double those for liquidated damages, and the purpose of that is basically an effort to kind of, I think, in a way, make whole, actually, because it's money that you didn't have. If you were underpaid, you didn't have this money at the time to invest it, to purchase a car, to pay your rent, to buy a house, to buy eggs. So it's an effort to kind of make up for that by giving you some sort of number that is a concrete number to kind of provide for those losses that are difficult to calculate otherwise. There's a flip. I believe that the effort to secure liquidated damages kind of across all cases was limited in the first Trump administration by the Wage and Hour Division and the administrator at that time. But we've seen it under President Obama and President Biden. I don't know that President Trump has acted yet, but we may be in a place where liquidated damages are less compulsory and, kind of back on the table for negotiation. But that's something to keep an eye on, because obviously doubling your exposure is a big deal. Certain states, to answer your question about treble damages, certain state laws that, you referred to earlier and obviously you need to comply with if you're operating in that state, have different numbers and different penalty structures. So you could see treble damages in certain localities.
Absolutely, and that's why, folks, you need to be reaching out to Scott at Carey, because he's going to help you do that analysis so that you know where you stand and you know what your exposure is. So, Scott, now I want to turn to this rule on independent contractors because I think that plays right into the OT question or overtime question. Can you help us understand what the independent contractor rule is currently and what's going on with it?
Yeah, so independent contractors versus employees. When you're an independent contractor, you kind of think those folks have a little bit more control over the way they execute a job, as opposed to an employee who is going to be, at their desk when their employer tells them to be, out in the field when their employer tells them to be, executing, whatever number of hours you have, and all those things, getting across the finish line how the employer wants you to do that. And sort of for that control, the employer, also in exchange provides benefits, the FLSA protections that we talked about earlier, minimum wage overtime, those kinds of things, that independent contractors aren't, necessarily getting those same protections. Certain jurisdictions, I think Washington State has some kind of, carryable benefits that you can bring with you, but typically as an independent contractor, you're not getting that. So under the Biden administration, they actually withdrew the President Trump independent contractor rule and replaced it with what is a totality of the circumstances test, meaning you're looking at everything that's out there, all these factual circumstances surrounding the employment relationship or the worker company relationship to decide, is this person an independent contractor, an employee? Are they going to get these protections under the Fair Labor Standards Act or not? And that was, at least a 6-factor test. And I say at least because, I think there was a catch-all that basically says, and anything else that matters. So that kind of leaves you a little bit in the lurch. DOL suggested at the time under the Biden administration, they were just sort of memorializing the approach that courts have taken in the past. But again, you're looking at a number of defined factors and then kind of this catch-all.
Yeah, and my understanding is that some of those factors are the workers' control over their work, how much they get to control the work that they do, what is their opportunity for profit or loss, meaning are they making a profit on the work or are they losing money and performing the work, right, which is something inherent to entrepreneurship and when you're running your own operation, and whether there are investments by the worker and the employer. We're both putting our money in to make this business happen. But like you said, many factors, but for me, those 3 stood out.
Yeah, and I think the way they were framed by the Biden DOL is also sort of why there was pushback from the business community here. The opportunity for profit or loss also had a depending on managerial skill. Okay, what does that mean exactly for this person who's an independent contractor? Or, what are the investments made by the worker and the employer? Well, isn't the employer always going to make a bigger investment? So how do you sort of factor in that relative investment between a single person doing one job and then a company that's whole operation is, that's what it invests its money in, right? It's to do its industry and execute. The Trump rule, the Trump 1.0 rule, his first administration rule, actually focused on 2 of those factors that you mentioned as core factors. And it said, if these go the same direction, that's likely what this person should be classified as. And so those were the nature and degree of the worker's control over the work and the worker's opportunity to earn a profit or loss. And so you look at those and you say, okay, these guys can do whatever they want to get this job done, within the designated time frame, of course, within reason, but they are operating without a whole lot of oversight from the employer or from the company that is engaging this independent contractor. And what's the worker's opportunity for profit or loss? And to me, that also means, not only on this job, but does this job allow me to take on other work? So an employee, you kind of think of, well, you have a job you're focused on, maybe you have 2 jobs you're focused on, but they're kind of independent of one another, right? When you're an independent contractor, you're going to need to go out there, you're going to need to make, develop business, as you refer to, the entrepreneurial effort that you put in. And so can you do that across a number of different jobs without this overarching control from an employer? I think those are the 2 things that the Trump administration's first independent contractor rule looked at. And so, it's important to understand, I think we said this, but just to restate it, it's important to understand that all these kind of benefits that go along with employment, the test matters, because if it's harder to be an independent contractor and it's easier to classify as an employee, then employers are going to wind up having to provide these benefits for more folks. And that's what the Biden DOL rule did. It basically, I would argue, and did in certain court filings, that it's easier to designate someone an employee under the Biden administration rulemaking. Folks in the business community appreciated the Trump era rule because with those two core factors, you knew where to focus, and it was a little bit clearer as to where you were going to land.
Where are we now? Which rule are we under right now?
Yeah, so the Biden era rule is in effect, but under challenge. It went into effect in March of 2024. The enforcement effort, it's hard to say. Now that we've turned over the administration, I would guess that, like a lot of policies, it's under review, and they're going to consider, do we keep defending this? Do we keep defending this rule from these challenges? Do we, try and maintain it? Or are we going to, is the administration going to go back, revisit it, potentially try and revert to something more like the Trump 1 rule, at least something aligned with that, with the core factors? And so, it's a little bit up in the air. I wouldn't expect that the Trump wage and hour division is going to, emphasize this 6, 7, 12 factor test, totality of the circumstances test right now as they consider what to do. But yeah, the challenge, at least, for example, in the Fifth Circuit, oral argument was scheduled, and they just pushed that out, I think 60 days. So, they're trying to determine, the administration is trying to determine how they're going to approach this. And I think there's a good chance that they don't continue to defend this rule. They look to maybe engage in rulemaking. And I would argue this isn't necessarily proactive rulemaking. I know we talked about how limited that's going to be. This is one of those falls under withdrawal rulemaking. They'll have to put something else out, to put back in place, but it may be easy if they say, you know what, we're back to the 2021 rule that I put out the first time, if you're President Trump. So I think that is a space where you may not see the multi-factor test, the larger totality of circumstances test last that much longer in this administration.
So I was reading something recently that talked about how there is division even among supporters of the current administration on the continuation of this rule. So I think it is really a great space. And I think if you are in a position of saying, well, we're not going to comply with the 6-factor test, and we're going to do a 2-factor test, and there hasn't been any decisions yet. Yeah. I think you need to be consulting with legal counsel over that, and you might
100%.
A call.
Yeah, 100%. No, I'd never advise non-compliance, Letitia. So, yeah, you need to know what you need to do right now. We're predicting that, what may happen going forward, but yeah, you should know what you need to comply with, and it's good to keep an eye on this. As we talked about, you need to be on top of these changes and policy shifts, new rulemakings that change your obligations. But yeah, it's important to know what's happening now and to be able to, support your classification decisions, really. That's the biggest thing, is to say, we landed on this because we looked at X, Y, Z, A, B, C, and decided this person was an independent contractor. And that makes it a lot easier for counsel, or if an enforcement action happens and you need to sort of defend your process to the wage and hour division, for example. If you have that there, you have it documented, it's reasonable, that goes a long way in making arguments that you did the right thing.
Absolutely. And again, you want to be consulting with competent, experienced legal counsel on this question, because I cannot tell you the number of times just overall in my career that, sometimes it's, well, we gave the person a 1099, so that makes them an independent contractor. Or they said they wanted to be an independent contractor, so they're an independent contractor. And you're going,
Yep.
I don't know if that's the test. You need
Yep.
legal counsel to be advising you. So even if you're on the fence, I would say reach out to legal counsel to get some guidance in this space. I want to also point out that with respect to industries most impacted by this, I'm thinking it's like the gig economy type of work, or even in the construction industry. What are your thoughts?
Yeah, I mean, I think the gig economy is a huge one. Obviously, I referred to the portable benefits issue, which I think, states like Washington, I believe, came up with a plan to kind of address that. But yeah, folks like Uber, DoorDash, those kinds of entities, that are providing these sort of one-off services to folks, and it's part of their business structure is the independent contractor model, and to say, okay, all these people are now employees really changes things. We referenced budgeting earlier, and if you're looking at, okay, how now I have to do minimum wage, overtime, provide workers' comp, whatever other benefits may be required, you're in a different space than if you're kind of having someone do these at their kind of option and in the time they have available. I know there's data out there that suggests a lot of these folks, the workers, actually like the model to be able to kind of take on that work when they have the time and availability and motivation to do it. And so, I don't think, to your point, it's not like there's not like 50% of people agree, think this, and 50% of people agree with that, and there are obvious like groups on that. You may have workers who support this, and you may have businesses who want to provide more benefits to their workers. So there's some flexibility here, and I think in general for employers, the folks we represent, just having clarity and time, what do I have to do and when do I have to do it, is super helpful. And so that's why I think the earlier rule, the Trump administration rule, a lot of business interests because it was like, here are the core factors to look at first. And you didn't have an HR person sitting in a room with their list of employees and going, all right, well, I've looked at the 6 factors. What else could like the 7th factor be that I need to guess at that DOL wants me to know? And it's just a time intensive thing to look through 6 factors for every person you have and try and figure out, what's going on here. So, I think there's some questions that, could be answered on both sides and make it a clear, more understandable function. I think we'll see how it plays out, but I would expect that you may see something more like the core factors going forward.
Absolutely. And I don't know, do you have any updates or awareness of the FLSA suit regarding the student athlete status as employee?
I don't, honestly.
Okay.
Sorry, Letitia.
Okay, we'll edit that part out.
Yeah, that one's on
me.
But
we'll edit that out because I think that's still tied up in the courts, and I can just say that. I think in terms of the FLSA suit involving college athletes and whether or not they are employees under the statute and are eligible for overtime, that is still up in the air. Another reason why this is important, Scott, is because if employees or if individuals are designated employees under FLSA, then that is very persuasive at the NLRA space, right? The National Labor Relations Act space,
yep,
when we're talking about whether or not individuals are employees under the act, right? Student athletes, for example, right? So if student athletes are designated employees under the FLSA, does that mean that counsel for those individuals could then turn to the NLRB, the National Labor Relations Board, and say, hey, this agency said that these student athletes are employees, and so therefore they should be employees under the National Labor Relations Act and entitled to the right to unionize and collectively bargain about now what are terms and conditions of employment.
Right. Yeah. No, I mean, that would be huge for the NCAA and everything that goes on there. If you had student athletes who were no longer student athletes, but employee athletes, I think is a different animal. I mean, you're looking at basically a professional minor league, kind of organization.
Absolutely. All right, let's go into Title VII enforcement. And I mean, we have seen a flurry of activity involving one agency primarily, and that's the Office of Federal Contract Compliance Programs, OFCCP. Can you talk about that, Scott?
Yeah. So we saw a number of executive orders came out in the initial days of the Trump administration. One of them being a January 21st executive order that was titled Ending Illegal Discrimination, Restoring Merit-Based Opportunity. And that was in the sort of contracting space. It's addressing, government contractors, and what OFCCP did, and we'll see where it goes. But what it did was, enforce the executive order from Lyndon Johnson, 11246, which was designed to ensure federal contractors took certain measures to ensure non-discrimination. You maybe had to have an affirmative action program, things like that. And that order has been rescinded, and so OFCCP, which basically used to enforce that order, that was a large part of its work. And I know you worked there, Letitia, so but having that revoked, OFCCP's website is now like, we're redesigning our website to comply with this new executive order. But it used to say stuff like, we enforce the law, like 11246, or we promote diversity. And the executive order said, you cannot promote diversity anymore. That sort of is directly in conflict with what OFCCP did before. And so I think OFCCP is needing to figure out, okay, what is its role now? For example, the executive order requires contractors to certify that they don't operate programs promoting DEI that violate any federal anti-discrimination laws. So rather than kind of going in and making sure you're having an affirmative action program that ensures, equality of opportunity, for example, you're going to have to make sure, I think you're looking at it in a different way, in that you need to make sure that's true, not necessarily for the folks it was originally designed to protect, the sort of marginalized folks without as much opportunity or access to opportunity. You're going to have to make sure that it's, equal to everyone, I guess. You're not bumping up any one group. That seems to be a pretty big positional shift. And withdrawing 11246 is, a big deal. That's 60 years of process and procedure that's, a stroke of the pen took away quickly.
And I want to encourage people to really know what the Executive Order 11246 says, what the federal code says in terms of compliance, because DEI is a new term. That's something that's new. This happened in 1965.
Yep.
That's right after the passage of the 1964 Civil Rights Act in Title VII. So this was designed to ensure that we have compliance with the new federal law, Title VII, right? And so the whole DEI, that's like new stuff. When I think about it, I think of sort of, I want to say either millennial and Gen Z versus like, I don't know, maybe what's the 1965, like boomers.
Boomers, yeah.
Boomers, right? So it's just a different mindset and different, I think, understanding of this same executive order that has existed for this entire time. And so I want people to understand what it is and go back and look and make sure you have a clear understanding on both sides, whether you're an employer or you're part of an employee group, because I think sometimes there's misunderstandings on both sides. Everybody's just going off of what they heard as opposed to what is. So what, you talked about whether or not we see OFCCP doing the same types of activities they were doing before in terms of like the desk audit and on-site audit and reviewing affirmative action plans submitted by federal contractor employers. I think it's just TBD on that, right?
Yeah, I mean, I think the question is, what's the shift? If contractors are certifying that they don't operate these kinds of programs that promote DEI, which is, I think, the term in the, that's used in the executive order, is that now what OFCCB does as opposed to, enforcing 11246? The other thing that at this point doesn't seem to have been touched by the executive order is VEVRA, which is Veterans Protections, as well
Yes.
as Section 503 of the Rehabilitation Act, which deals with employees with disabilities. And so
Yes.
those investigations on those fronts have been paused pending additional guidance, but the EO didn't address them specifically. So that could be a piece that's still kind of OFCCP business as usual, or as close to usual as can be. But when it comes to the 11246, you are looking at the order. It specifically said that OFCCP needs to immediately cease promoting diversity, holding federal contractors and subcontractors responsible for taking affirmative action, and allowing or encouraging federal contractors and subcontractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. And that was, I think, what the AAPs, the affirmative action programs under OFCCP's purview and derived from 11246 were kind of meant to do. It's, if you look and you see that, oh, we're falling short with a particular group here, why is that? And how do we provide the opportunity to make our business look like how the workforce should, or how society looks? Arguable. I don't want to, you said we're not going to get into the politics, so I won't. But, I think.
Yeah, we're just talking the facts. That's
yeah,
all.
it was not. It was not
what it is.
Yes, the opportunity was to sort of ensure broader recruitment and to make sure you're taking into account certain, taking into account maybe systemic biases or things. As you said, this came out at the time that we're looking at Title VII and Civil Rights Act and things like that. So it's another avenue to kind of hold people accountable to those ideals at that time. I don't think it was something that was designed to put marginalized folks into positions they were unqualified for. It was to make sure those folks got the opportunity where they were qualified to not lose a job to, the majority, an unqualified person in the majority. So it's a little bit different than maybe it's been reported and, the public comments on this. So, we will see, as you said, TBD on exactly what OFCCP's role is here and what kind of certification reviews they're going to need to do of these contractors that they are complying or not, they are not in violation of anti-discrimination laws. I think, the fact that the website is updating to align with the EO, we may get a better idea when they put out publicly kind of what their new focus points are.
Yeah, that's a great point to sort of turn to our conclusion on. We are coming at time here, Scott, and thank you so much for taking time out of your busy day. I know you're a working dad, and your wife's a working wife too, so the whole family's working.
True enough.
But I want to thank you for taking time out to connect with me on this. Can you give us or give employers, our audience, just a few tips that you want to leave them with as they are thinking about and trying to digest everything you just said?
Yeah, I mean, I think we talked about federal contractors because that's sort of the first tier of this executive order, but I just want to note that it does then turn its eye to the private sector, and it directs agencies, including, with the Attorney General and heads of agencies and the director of OMB, to submit a report to the Assistant to the President for Domestic Policy to recommend ways to encourage the private sector to end illegal discrimination and preferences, including DEI. So it's not just going to be federal contractors. They have directed folks to come up with a list of potential, I think they say the most egregious and discriminatory DEI practitioners. And we've already seen some announce that I think FCC is going to investigate Comcast and NBC Universal for their DEI policies based on, I think, what's on the website. So things to look at. If you don't want to wind up on that list, if you want to minimize your exposure, you do need to, I think, look at your public-facing documents on your programs that could arguably be classified as DEI. You need to think about how do we maintain our principles while maybe not inviting the government in to turn things upside down and do an investigation. Because any enforcement activity under the Biden administration, Obama, whoever, Trump, that is disruptive to your business. It's not meant to be, but it is. It takes time. It takes resources. So consider what your programs look like. Consider how, again, you can maintain your principles while still taking account, if you're a federal contractor, that you can appropriately certify that you don't have a violative program. And if you're a private employer, to minimize risk and not appear on one of these lists of entities for investigation. There's exposure there, not only enforcement exposure, there could be False Claims Act exposure. I'm not going to get into that because I'm no expert, but that is if you get paid by the government and you've made a false claim on your invoice to pay. So for example, if you certify that you don't have a violative program and then they decide you do, you may have monetary exposure there. So there are issues here. You need to consult counsel. Con Maciel has experience looking at DEI programs. Reach out to your competent counsel, figure out how to address this and how to minimize your exposure, mitigate risk by thinking about what your programs, how they read and how you publicize them, and really what their impacts are. Because I think right now we don't have a ton of guidance on what an illegal DEI policy looks like, right? And I think we have no history on this. And so it'll be interesting. I say interesting euphemistically, as we figure out what the parameters of these things are and what is going to raise the government's ire in this space. We're not going to know that for sure until we have some history on it. And you don't want to be the first person. You don't want to be leading that.
You don't want to be the test.
Yeah. You don't want to be that. You don't want to be that first company that's name is associated with these kinds of activities. And the first civil money penalties that are issued for this or whatever it is. So we'll see, but I think it's really about kind of getting your hands around what your programs are and how you can mitigate those risks going forward. And as you've noted, consulting competent counsel is a good place to start.
Absolutely. And so I want to thank everybody for tuning in with us. Pay attention to those independent contractor tests. Pay attention to what's happening on the DEI front. Call us here at Con Maciel Carey. We have experienced attorneys who speak your language, meaning we don't get it bogged down in legalese. We just tell it like it is, and we help you navigate these complicated spaces. On our next episode, we are going to continue the discussion on our follow-up to our webinar on forecasts for 2025 in terms of workplace law, and we are going to focus on changes that we are seeing at the National Labor Relations Board. Until next time, stay ready so you don't have to get ready. Thank you, Scott.
Thank you, Letitia.